Does a tenant of premises which could only be used as a cinema have to pay rent for the period the cinema was forced to close because of the coronavirus regulations? Spoiler alert, yes it does. Does it matter that the landlord took out insurance at the tenant's own expense, which would pay out in the event that there was a loss of rent caused by the pandemic? No, it doesn't. That's the decision handed down today by the Court of Appeal in the conjoined appeals of Bank of New York Mellon and Cine-UK Limited, known as the Hengrove case, and Picturehouse Cinemas Limited and London Trocadero, known as the Trocadero case. I acted for the cinema tenant in the second of those appeals, the Trocadero case, led by Jonathan Seitler QC. And here's 6 or 7 minutes on the two main arguments and how the Court of Appeal reached its decision. So the first main argument concerned rent cesser, where damage was caused by the pandemic. This was only relevant to the Hengrove case only, because the Hengrove case only had a relevant insurance policy here. The landlord had insurance which would pay out if there were a loss of rent caused by the pandemic. The insurance premiums were paid for by the tenant through the usual mechanism of the lease. And the lease had a standard form rent cesser clause which provided for rent to be suspended in the event of damage or destruction to the property. So the tenant said, the insurance policy bites because there has been a pandemic. It will pay out if we don't pay the rent. That's what the policy is there for. And properly understood, the property had been damaged by the pandemic in just the same way that the property might be damaged if a strike had caused loss. So the rent cesser kicks in. And the tenant said, that's a fair result. We've paid for this insurance. The very disaster against which has been insured has happened, so it shouldn't have to pay rent. But the Court of Appeal said that was wrong for two reasons. First, there wasn't a loss of rent caused by the pandemic. The loss of rent was caused by the decision of the tenant not to pay rent. The loss of rent would have been caused by the pandemic if, because of some other provision of the lease or a different rent cesser clause, the tenant was not obliged to pay rent. But that wasn't this case. Secondly, the Court of Appeal said the property hadn't been damaged by the pandemic. Damage meant physical damage. Now, of course, this is all a matter of construction of the particular policy and the particular lease in this case, and each case is going to turn on its own facts, but the direction of travel in these cases is pretty clear. Right, so on to the second main argument, failure of basis. The tenants in both cases said that the law of restitution should come to their rescue, but the Trocadero case took the lead on this argument. So the argument was there was a fundamental premise to the leases that the premises would be capable of lawful use. And that was founded upon the user clause, which said you can only use these premises as a cinema. And it was said, objectively, everyone went into this lease on the basis that those premises could be lawfully used as a cinema. Of course they did. And that fundamental premise, so the tenant said, failed when the coronavirus regulations came in and forced the cinema to close. So there was a failure of basis. And the result is that any money that was paid by the tenant would be immediately repayable in restitution. Now, there's loads of complexity to this. There were questions over whether rent could be apportioned daily or quarterly, so that it could be said that there had been a total failure of basis. We all know that for failure of consideration, failure of basis to work, it must be a total failure. So if you can apportion the rent daily, you might say that for a day that the regulations were taking into effect, there had been a total failure. Whereas if you can only apportion your rent quarterly, then if the regulations came into effect partway through that quarter, there might not have been a total failure of basis. There were questions over whether failure of basis could in effect operate as a freestanding defence through the prism of a set-off. This was really quite intricate. In essence, restitution operates only as a claim to get money you've already paid back. That's because the failure of basis is one of those unjust factors which leads to a claim in restitution or claim in unjust enrichment. But we said, if the tenant had paid the rent, because in this case, for much of it, the tenant hadn't actually paid it yet, it was refusing to pay. But if the tenant had paid the rent, it would have had an immediate claim in restitution, provided failure of basis was otherwise good. So come off it. It shouldn't have to pay the rent in the first place. Otherwise, you just got money going backwards and forwards. This was the prime case for a set-off. There were also questions over whether ancillary use, storage at the premises, office space, etc., was that enough to mean that there hadn't been a total failure of basis even on any given day during the pandemic, because there was some use that could be made of the premises. Now, ultimately, the Court of Appeal decision turned on two fundamental points. First, in order for the doctrine of failure of basis to operate where there is a contract which is ongoing, where it subsists, like a lease in this case, it's necessary to find a gap in the contract where it doesn't provide for the particular circumstance encountered, so that the law of failure of basis can come to the rescue. Now, we said there was a gap. The leases had a rent cesser provision which said, in certain defined cases, like fire, the rent would be suspended. But we said that tells you absolutely nothing about what happens in other cases. It's silent in that regard. There is a gap to be filled. But the Court of Appeal said that, in effect, the rent cesser provisions were a complete code. Where there was no express rent cesser, rent would be payable. So there was no gap to be filled. The risk had been comprehensively allocated between the parties. The second big point the Court of Appeal relied upon was that the basis of the obligation to pay rent was the grant of a demise. Now, we said that that was one basis, but not the only basis. So, of course, the basis of the the basis of the obligation to pay rent was the grant of a demise. If there hadn't been a grant of a demise, of course the lease would have failed. But we said also, of course, both parties objectively went into the lease on the basis that the premises would be capable of lawful use. You can have two bases. But the Court of Appeal said our second basis was inconsistent with the express term of the lease, providing that the rent was in consideration of the demise. And there we have it. Now, as I said, there was plenty of complexity to this case. The Court of Appeal might be said rather to have skated over it and to have missed an opportunity to comment on hot topic and rapidly developing law. But there we go. For present purposes, and although each and every case is going to turn on its own facts, you've got to study these leases very carefully, you never know what you might find, it looks like in almost all cases tenants will have to rely upon the binding arbitration scheme brought about by the Commercial Rent Coronavirus Act 2022. But of course, to do that, you've got to get your skates on, as the deadline to make references to arbitration is really rapidly approaching.